I am Palak Agarwal of Hidayatullah National Law University and currently a legal intern at LEXIS and Company. The word nuisance is derived from the French word nuire, which means to harm. Nuisance means any substantial or unreasonable obstruction to the use, enjoyment, or peaceful possession of land or any public right. The way of interference may be noise, smell, smoke, vibration, heat, excavation, or disease causing germs. Nuisance can be of two types, either private or public. Both types of nuisance are distinct from each other in the character and the remedies available to them. According to the section 268 of the Indian Penal Code, a person will be guilty of nuisance who does any act or is guilty of an illegal omission which causes any common injury, danger, or annoyance to the public or people at large who dwell or occupy the property in the vicinity, or which must cause injury or annoyance who may have occasion to use the public right. Public nuisance is not a tort, it is a crime. If the party hall plays loud music every night till 2 a.m. in a residential area, then the party hall owner is responsible for public nuisance. If a person releases a gas that makes everyone passing through that area to cough continuously for 2 hours, then that person is responsible for public nuisance. However, in all these cases, only one action can be brought against the person. If every suit by every affected person is allowed, each person guilty of public nuisance will be ruined by hundreds of cases. However, in selected cases, the court may allow a person to file a private case against the defendant. However, in this case, the plaintiff must prove that the injury caused to him was more than the injury caused to other persons. His injury was direct and not consequential in nature, and he suffered a substantial amount of injury. For example, if a person obstructs the public highway on a busy day, he will be liable for public nuisance. Because of such obstruction, a person was delayed to go to his office because of which his salary was deducted. In this case, the person cannot file a case separately on the defendant, as he cannot prove that he was injured more than anybody else. On the other hand, there was a person in the ambulance with his pregnant wife who was in labor and was suffering from various complications, and because of the obstruction had to be airlifted to the hospital, costing the person over 3 lakh rupees. The person can say that he suffered both mental and monetary injury because of the person's obstruction, and that he suffered more than anybody else. His claim of private compensation may be allowed. Private nuisance is using one's property or authorizing the use of one's property or of anything under one's control so as to injuriously affect a owner or occupier of the property, or by interfering materially with his health, comfort, or convenience. Private nuisance is a tort as opposed to public nuisance, which is criminal in nature. Private nuisance may lead to an actionable claim and not a police complaint. The first essential for private nuisance is that the person's property should not be directly infringed with. The person's right to enjoyment of the property must be interfered with. The interference must not be construed as trespass. An act can either be trespass or nuisance, but it cannot be both. A noisy dog who barks every day at night can be said to be private nuisance. Private nuisance would said to be occurred when there is a substantial interference with the person's right to enjoyment of property. The interference is tested with the cornerstone of reasonableness. An extra sensitive person will not find a relief in a suit for private nuisance.